Our guest today, Scott Kimpel, is a partner of Hunton Kurth in Washington, D.C. A decade ago, he worked at the SEC on the staff of Commissioner Troy Paredes. He's one of those guys that seems to know everything. I'm Brock Romanek, today on Zippy Point. So Scott, let's start with the Compensation Committee report and the proxy. What's the required form of it? Why is it a report within a proxy? It just on its face wouldn't make sense if you didn't know what the rules were.
Right. This is another one that has kind of a long history going back to the early 1990s and sort of the change in philosophy that the Commission and society more broadly has had on ways to rein in executive comp. And actually, the form of the report has changed quite a bit over the years. Again, with the 2006 reforms to executive compensation disclosure, it was pretty much overhauled. The current requirements for a compensation committee report are in item 407E5 of Regulation SK. And they provide that under the caption Compensation Committee Report, the board's comp committee or its equivalent must state that, one, the committee has reviewed and discussed the CD&A with management, and two, based on that review and discussion, the committee recommends inclusion of the CDA in the proxy statement. Then underneath that, the name of each committee member has to appear. And I think this is part of the larger trend of making people sign things to put them on the hook. Particularly after Sarbanes-Oxley, we got really heavily into certifications, and this is just another example of, all right, if my name is actually listed with this thing, then maybe it has a little bit more efficacy than if it doesn't. This has become kind of a pro forma disclosure that's made. I mean, obviously, the committee reviews it as part of the overall disclosure package when they're preparing the proxy statement. But you don't very often see people changing the form language or giving it a whole lot of thought.
And how's the liability for the Compensation Committee report different than the other disclosure in the proxy?
This is another one where Section 18 comes in. Section 18 provides liability for certain filings made under the Exchange Act. There's a distinction between things that are filed with the Commission and things that are furnished. And this report is another one that's merely furnished, so there is no Section 18 liability under it. It's also not deemed incidentally soliciting material for purposes of the proxy rules and Rule 14A9, which is a separate anti-fraud rule that only applies to proxy solicitations.
So what's the relationship of this report to the CD&A?
So this is another one where the pre-2006 version of the report included a lot of information that's now been moved around and actually integrated into CD&A. What's left in the streamlined report is the assurance that the comp committee has reviewed CD&A and is comfortable with it, and that it fairly summarizes the company's policies and philosophy on executive compensation. In contrast, item 407 of Reg SK picks up a range of disclosures regarding a company's corporate governance and risk management, and including with respect to governance and operation of the comp committee itself. So I see the two as very complementary to one another.
So what's required to be disclosed about the Compensation Committee members under item 407 of SK? Independence and interlocks.
Yeah, there's a number of items there. You start with having to disclose whether there is a standing compensation committee, and if not, why not? If there is a compensation committee, then the issuer is required to disclose the membership of the committee, the number of meetings that it held during the last fiscal year, and a general description of the committee's functions. They're also required to disclose whether the committee has a charter. If they do have a charter, if it's on the company's website. If it's not on the company's website, they have to file it as an exhibit to the proxy statement. And item 407 also requires a narrative description of the processes and procedures for determining executive officer and director compensation, including the scope of the committee's authority, the ability to delegate that authority to third parties, the role of executive officers in making recommendations to the committee, and the role of any outside consultants to the committee members. Finally, 407 requires disclosure various related party transactions and whether there are overlapping relationships of one company's executive officers and directors with another company's compensation committee. All of that's required to be disclosed under the heading Compensation Committee Interlocks and Insider Participation.
And you have negative disclosure if you don't have interlocks, or you just can omit that section?
I think a lot of companies omit it these days. if they don't have any. I mean, it's rare that you see that. I think this was another one when we had much more of the overboarding phenomenon where you had, lots of directors serving on 5, 6, 7 boards. Nowadays, the trend is to try and reduce that number so it just comes up less frequently. And certainly with CEOs, their board and one other is kind of the gold standard now from some of the different governance gurus.
Yeah, it's one of those areas where the SEC used disclosure as a way to change governance practices, since
That's right.
They don't have the authority to actually mandate changes in those practices themselves.
That's right.
So, Scott, what's supposed to be disclosed about the role of the compensation consultant in the proxy?
This is the subject of significant attention, both in the SEC's rules, and then a lot of it gets hardwired into the stock exchange listing standards themselves. But basically, companies must disclose the role of any consultant in recommending the amount or form of executive or director compensation. And if so, they must identify the name of the consultant, whether the consultant was hired by the committee or the company, the general scope of the consultant's engagement, and any material instructions the company provided to the consultant.
So what about the independence or any conflicts of interest of the consultant? How is that handled in the disclosure?
Yeah, so that's another one where the SEC wrote rules compelling the exchanges to in turn write rules. And what NYSE and NASDAQ came up with are pretty similar. The committee is required to consider the independence of the compensation consultant, giving consideration to 6 factors: any other services provided to the company, the amount of fees, and the percentage of total revenue that those fees constitute, any screens or other policies to prevent conflicts, any business or personal relationships with any committee members, whether the consultant owns any company stock, and any other business or personal relationships that may impact the engagement. And these rules apply not only to traditional compensation consulting firms, but also to outside law firms that are serving in that similar kind of capacity, which was a bit controversial at the time the rules were adopted, but hasn't really been much of an issue since. And I guess it's worth pointing out that the actual NYSE and NASDAQ listing standards don't necessarily require the consultant to be fully independent. They just require the committee to consider whether it's independent before they engaged it. As to conflicts, there's a similar kind of, it's actually the same 6 factors. And if any of those factors are present, presenting a conflict, then it becomes a disclosure issue. That's another one where folks understand the ground rules. The compensation consulting firms try not to have so many extenuating relationships with issuers that this creates a disclosure issue in the first place. Some comp committees are also gun shy about using consultants that have lots of different relationships. They want to just keep them laser focused on one thing or another. So again, in practice, I don't see this coming up a lot. Occasionally it does, but usually it doesn't.
And what if a company is hiring a consultant to provide guidance on broad-based, non-discriminatory plans?
Yeah, there's actually an exception. So item 407E3 Roman 3 does provide an exception to the disclosure requirement when the consultant's only role is to recommend the amount or form of executive or director compensation under a broad-based plan that does not discriminate in form, does not discriminate in favor of the executive officers or directors. Incidentally, there's also another exception under E33 for a consultant that only provides generalized information, such as peer surveys or benchmarks that are either not customized for a given client or were otherwise prepared based on the consultant's own criteria and not in response to a tender from the company itself.
And what about disclosure of the fees paid to a compensation consultant? Are those disclosed?
In certain circumstances, they are. I find the rules somewhat awkward to interpret. And the exceptions I just described apply. So if one of them is available, then there's no disclosure. Otherwise, disclosure about the consultant's aggregate fees is required when the consultant provides so-called additional services to the company. For these purposes, the SEC interprets additional services quite broadly. Anything beyond core advice related to executive officer and director compensation is considered additional services. So under the most typical scenario, disclosure is required of fees if the consultant provided additional services outside the core function, and those other fees exceeded $120,000. If those conditions are met, then the disclosure must disclose the total amount of fees, whether management was involved in the decision to engage the consultant for the non-executive compensation services, and whether the board or comp committee approved these additional services. Again, this is an area where through disclosure, I think the commission was trying to discourage certain practices. So while you do sometimes see the compensation consultant providing what amount to additional services, again, this is an area where a lot of companies just don't want to have to make that disclosure, so they just don't do it. You know, they might hire two different consultants, one that's subject to the rules and one that might provide other services that aren't.
And then is the consultant supposed to review or consent to the disclosure before it's included in the proxy that's filed with the SEC?
There's no legal requirement to do so. The commission doesn't view the consultant's input to be the sort of expertise report where consent's required. So it's not on the same plane as an audit report or an engineer's reserve report that does require an affirmative consent. As a practical matter, though, most companies have the consultants read, reread, and reread the CD&A and provide lots of comments. So they're usually heavily involved in its preparation and its review. It's rare, I think, that you would have a consultant that provides input and then they at least not get one look at the draft.
And what is the relationship of this disclosure to the CD&A?
I think the best way to think about it is that the comp committee disclosure narrowly focuses on governance structure over the committee's process. And CDA, on the other hand, focuses much more broadly on the material information about the company's overall policies and philosophies on executive compensation. And CD&A, of course, also includes the actual quantitative disclosures about compensation and other benefits. So again, the two sort of work hand in glove with one another.
That's great. Thanks so much for all your knowledge, Scott.